me. I'm Evelyn Aka, founder of Aka Business Immigration Law. Today, I want to talk about something that creates a lot of confusion for companies moving people across the Canadian border. When is someone simply coming to Canada for business, and when are they actually coming for work? I hear this all the time. They're only coming for a few days, maybe 3 days. They're still being paid by our company outside Canada. Or they're just here to help the Canadian team for a short term. It's only a business trip. But none of these statements by themselves answer the immigration question. A short trip does not automatically make someone a business visitor. Being paid outside Canada does not automatically mean a work permit is not required. And calling someone or something a meeting, training, or business support does not change what the person is actually doing once they arrive in Canada. The real question you need to ask is, what activities will this person physically perform while they are in Canada? That distinction matters for companies sending executives, managers, employees, and technicians and specialists into Canada. Getting it wrong can create problems at the border, disrupt a project, and potentially result in an unauthorized work, which is a real problem. This discussion is for general information only. It is not legal advice. Every company, traveler, and assignment has different circumstances. Call us to be focused on yours. Today, I'm going to explain what Canada considers work. What visitors can generally do and what is considered a business trip in terms of your activity. Before somebody gets on the plane, you need to know. So let's get started. The first thing companies need to understand is that Canadian immigration law does not decide whether somebody is working based only on where their salary comes from. IRCC describes work as an activity for which wages are paid or commission is earned. An unpaid activity can also be considered work when it competes directly with activities of Canadians or permanent residents in the Canadian labor market. For instance, would a Canadian be paid to do this activity? If it is the case, then they are considered to be working. That means someone can remain employed and paid by a company in the United States or elsewhere in the world and still be deemed to be completing work in Canada. And this is an important misconception. Foreign payroll alone does not automatically protect the person from Canada's work permit requirements. Instead, we have to look at the actual activity that is being done. Are they attending meetings? Are they negotiating a contract? Are they simply observing a Canadian operation? Or are they sitting at a desk, managing a Canadian project, repairing equipment, producing deliverables, providing technical services, or doing work that would ordinarily be performed in the Canadian labor market that would be deemed to be working? Those are all very different situations. A business visitor is generally someone who comes to Canada temporarily for international business activities without directly entering the Canadian labor market. There are a few important elements of this category. The person's main place of business should remain outside Canada. Their main source of income and profits should remain outside Canada. They should generally be coming for a temporary visit of less than 6 months, generally even less than a week or two. And most importantly, the activities they're performing in Canada need to be consistent with business visitor rules. I want to emphasize the last point because employers sometimes focus only on payroll, and payroll is not the compelling factor. They say we aren't paying the person in Canada, so they're a business visitor. It's not necessarily the case. Another employer says they're only staying for 1 week. Again, that doesn't necessarily answer the question, are they working in Canada? Duration matters, but activity matters more. Before sending anyone into Canada, the company should be able to explain very clearly what that person is coming to do and why those activities fall within the business visitor rules. And they must have a letter they provide to their employee to ensure there's consistency with what they're saying verbally and what they can produce if needed. There are many legitimate business activities that can be carried out in Canada without obtaining a work permit. Some examples identified by IRCC include attending meetings, board meetings, conferences, conventions, and trade fairs. A business visitor may come to buy Canadian goods or services for a foreign business or take orders for goods or services. Certain training activities can also qualify if it's within or an organization, for instance. For example, an employee working outside Canada may come to receive training from a Canadian parent company. A foreign employee may also come to train employees of a Canadian branch of that foreign company. Someone may also receive training from a Canadian company that sold equipment or services to their foreign employer. Certain after-sales services connected with the warranty or sales agreement may also fall within the business visitor category. That's called business visitor after-sales service. So business visitor does not mean you have to sit in a conference room all day. However, there can be legitimate commercial activity that does take place, but the activity must stay within the boundaries of the exemption for business visitor. And this is exactly where companies need to be very, very careful. The risk starts when the person moves from conducting international business into actually performing services or productive work in the Canadian labor market. That's when you move from business visitor into working. Here's a simple example for you. An executive flies to Calgary for 3 days to meet the Canadian leadership team, review strategy, negotiate an agreement, and attend a client meeting. That may be very different from an executive who comes to Canada for several weeks and actually takes over the day-to-day management of the Canadian operations. That's considered work. Or imagine a foreign technology company that has a contract with a Canadian client. Sending an employee to Canada to meet the client, review requirements, or discuss implementation may be one thing. Sending that employee into Canada to actually perform the technical services required under the Canadian contract may be another thing. IRCC specifically gives the example of an employee sent by a foreign company to fulfill a contract with a Canadian company as someone who may not qualify as a business visitor and may require work authorization. So companies need to stop asking the question of themselves, is this a business trip? And instead, they need to ask the question, what exactly will this person be doing every day there in Canada? That is a much better immigration question to ask so you can better prepare and know that you're on side. This is another area is we were talking about technical specialists, where we see companies get into trouble regularly. A Canadian company buys machinery, technology, or specialized equipment from a foreign supplier. Something needs to be installed, serviced, repaired, or tested. And the foreign company says, we'll just send our technician up for a few days. That should immediately trigger an immigration review for your organization. There are circumstances where after-sales service performed under a warranty or sales agreement can fall within the business visitor rules. IRCC specifically recognizes certain after-sales service as a permitted business visitor activity. But that does not mean every technician entering Canada to install, repair, or service equipment automatically qualifies for after-sales service business visitor category. You need to look at the contract. What was sold? What does the warranty or service agreement actually require? What will the technician physically do? And how long will they be in Canada for? Are they supervising or advising, or are they performing active hands-on work or productive work? And is the activity actually connected to the international sale or warranty arrangement of that initial contract? Do not wait until the technician is standing at the airport answering questions from a border officer to figure this out. You need to know in advance before you send your employee. Review it when the Canadian contract is being negotiated. Make sure you have the right provisions to allow you to do what you need to do and bring people into Canada successfully. The same principle applies to executives and managers. A senior title does not automatically make someone a business visitor, even if they're not doing active hands-on technical work. An executive can absolutely travel to Canada for legitimate business visitor activities, such as meetings, negotiations, conferences, and certain corporate discussions. But if the person is coming to Canada to actually perform an ongoing role within the Canadian operation, manage employees, carry out operational responsibilities, or provide services to the Canadian business, a work permit may be required. And that does not automatically mean an LMIA is required. Depending on the facts, there may be an LMIA exempt work permit category available, including categories involving intercompany transfers or international trade agreements. The important point is to identify the correct immigration category before the assignment begins. Business visitor and work permits are not interchangeable labels. They're only coming for 2 weeks is not the rule, okay? Another misconception I want to address is duration of time in Canada. People assume that if the assignment is short enough, no work permit is required. That is not the general rule, and it's not necessarily accurate. Someone can perform work during a very short trip and be seen to be working with unauthorized. There are specific work permit exemptions for certain short-term workers, but these are separate legal exemptions with their own requirements. For example, under the Global Skills Strategy, certain highly skilled workers in Tier 0 or Tier 1 occupations may qualify to work without a permit for up to 15 consecutive days once every 6 months, or up to 30 consecutive days once every 12 months. That is the global skills category. That person may legally be performing work in Canada without holding a valid work permit because they qualify for a specific work permit exemption. That is different from saying they are a business visitor and entering and doing work. This distinction matters. It can be complicated, which is why you need a professional. Do not create your own exemption simply because the assignment is short. The other thing is important is to prepare the traveler at the border for the entry at the border. Once the company has determined that the person qualifies as a business visitor or under another exemption, the next step is documentation. The traveler should be able to explain clearly why you are coming to Canada, who do you work for, who pays you, how long will you stay in Canada, what exactly will you be doing while you are in Canada, and who are you meeting with, and when are you leaving. These are absolute requirements. IRCC recommends that business visitors travel with supporting documentation from their employer, which may include a letter from their foreign employer, an invitation letter from the Canadian company, any relevant contracts, warranty, or service agreements, and contact information for the Canadian host. The documentation and the traveler's explanation need to tell the same story, and they must be consistent. Do not prepare a letter saying someone is attending business meetings when their itinerary shows 5 days of installation work at a Canadian client site. Do not tell the traveler just to say, I'm here for business. It's not enough. Prepare them to explain the real purpose of the trip accurately and as specifically as possible. And remember that even someone who does not need a work permit may still require the appropriate visitor visa or electronic travel authorization to travel to Canada. Here are some of the most common mistakes I see companies make when it relates to this, assuming that a trip of only a few days can't be work. That's false. Assuming foreign payroll automatically makes someone a business visitor. That's also false. Describing every corporate trip as meetings without reviewing the real activities taking place. Sending technicians to Canada without reviewing the sales warranty or service agreements. Assuming that a senior executive does not need work authorization. Confusing business visitor status with a separate work permit exemption category. Failing to prepare proper supporting documents for your employees. Giving the traveler an invitation letter that does not match what they will actually be doing. That's offside. And waiting until flights are booked or the employee is at the border before reviewing the immigration requirements that are needed to let that person into Canada. Most of these problems are preventable, especially if you work with a licensed professional lawyer. The immigration review should happen when the assignment is being planned, not the night before the person travels. So in closing, the difference between a business visitor and a worker is not simply whether someone calls the trip business, and it is not decided only by how long they are staying or where their salary is being paid from. The most important question is, what will this person actually be doing while physically present in Canada? Meetings, negotiations, conferences, certain training, and some international after-sales activities may qualify under business visitor rules. But once someone begins performing productive services or entering the Canadian labor market, a work permit or another specific authorization or exemption may be required. So before sending an executive, manager, technician, employee, or specialist to Canada, do not ask only, do they need a visa? Ask instead, are they a business visitor? Are they coming to work? And what immigration authorization actually covers the activities they will perform? That question should be answered before the flight is booked and before the person arrives at the Canadian border. Thank you for joining me today on our LinkedIn Live for ACA Business Immigration Law. I'm Evelyn Aca, founder of ACA Business Immigration Law. Feel free to reach out to me with any questions you have. If your company regularly sends employees, executives, or technical specialists into Canada, make sure you have reviewed the immigration requirements before they travel. A little planning before the trip can avoid much bigger problems at the border. I look forward to answering any of your questions going forward. Feel free to reach out to me via LinkedIn or contact our firm at 403-452-9515 or reach out to us at contact@acalaw.com. Take care. Bye-bye.